So, very good evening, friends. Today we are starting with part 3 of IBC, and part 3 of IBC deals with insolvency resolution and bankruptcy for individuals and partnership firms. Section 78 deals with application, that to whom this part applies. And as we have already studied in the section 3 itself, that if the definitions are given in part 1, then they apply to the whole of the code. But the definitions which are given in part 2, part 3, part 4, part 5, they belong to that particular part only. So the definitions which are given here in part 3, they apply to part 3 only. So section 78. Section 78 says that this part shall apply to matters relating to fresh start, insolvency and bankruptcy of individuals and partnership firms where the amount of the default is not less than 1,000 rupees. So for a default amount of 1,000 rupees or more, this part will apply. Provided that the central government may by notification specify the minimum amount of default of higher value which shall not be more than 1 lakh. So even central government cannot increase this amount beyond 1 lakh unless they amend the code. Up to 1 lakh, if they amend it, then it will be by way of notification only. Like in case of part 2, in case of corporate persons, the limit was enhanced from 1 lakh to 1 crore by issuing a notification, and to 10 lakhs for corporate MSCs by issuing another notification. But if the government wants to increase it beyond 1 lakh, then amendment to the code is required. Although no such notification, even increasing it to 1 lakh rupees has yet been made. So no notification is there. So regulations relating to part 3 have not yet been notified in respect of individuals and partnership firms. Regulations, rules have come for personal guarantors to corporate persons only. Because personal guarantors to corporate persons are individuals. So that is why their regulations have been notified, because sometimes the company doesn't have anything. So the borrower wants to proceed against the guarantors. So that is why, to enable that provision, so that the provisions relating to companies are in full force. So that is why regulations and rules have come for individuals and partnership firms who have given guarantee to the corporate persons. Now section 79. Section 79 says, in this context, adjudicating authority means the DRT. There is a concept of associate here. In part 2, there is a concept of a related party in relation to a corporate debtor, and in 524 capital A, related party in relation to an individual. But here the concept is of the associate, and we will also see the significance of this word associate. Okay, what are the things required in case of an associate? What is the importance? Whether details of the assets belonging to the associate are required to be disclosed. Because here also there are different provisions in different sections. Sometimes they want the details of the family members, but sometimes they want the details of the associates. So we'll see in the relevant provisions what is the exact meaning and significance of the word associate. So associate of the debtor means a person who belongs to the immediate family of the debtor, a person who is a relative of the debtor or a relative of the spouse of the debtor, a person who is in partnership with the debtor, because the debtor here could be an individual or a partnership firm. So that is why the concept of partnership. So a person who is in partnership with the debtor. Suppose A and B are partners in a partnership firm, so then they are considered to be associate. So the definition or the concept of associate travels beyond the family. So person belonging to the immediate family, person who is a relative of the debtor or relative of the spouse of the debtor, and a person who is in partnership with the debtor. Then a person who is a spouse or a relative of a person with whom the debtor is in partnership. A person who is employer of the debtor or employee of the debtor.